Hi, everyone. I'm just letting folks come into the webinar, and we'll get started in about a minute or two. But thank you, everyone, for joining us so far. Okay, folks, I want to give us the most time possible to hear our panelists speak and to entertain questions from participants. So I'll get started now. Good afternoon, everyone. Welcome to the third webinar of the Justice Collaboratory's four-part series. These webinars spotlight the transformative power of partnerships with contributors to the second volume of The Notebook. The Notebook is a collection of art, scholarship, opinion, and insight that holds a divergent space in a traditional world, existing somewhere between an academic journal and a popular magazine. By blending the perspectives of academic research and lived experience, it expands the conversation about justice and safety to render a more complete picture of complex emotional issues. This volume is centered on the theme of solidarities, the people, the work, and the practices that lift our energy and bring us together. You can download the notebook for free at justicehappenshere.yale.edu, or you can order a printed version on the webinar events page. Throughout the webinar series, panelists will share lived experiences, research insights, and on-the-ground strategies that illuminate how solidarities take root in addressing some of the nation's most imminent threats to safety and justice today. Today, we will be discussing the article Carceral by Another Name, Reforming Civil Commitment by Marisol Orihuela and Kristin Lummus. We'll explore the legal, ethical, and human impact of carceral civil commitment practices and explore pathways toward reform grounded in solidarity and care. We will also be joined today by Dr. India L. Mills. Let me introduce today's panelists and get the conversation started. Kristin Lummus is a former Massachusetts public defender with a deep commitment to advocating for individuals with mental illness. Over the course of her career, she has represented clients navigating the intersection of the legal system, healthcare, and housing instability, with a particular focus on those confined in psychiatric hospitals due to a lack of appropriate community placement. Her work highlights the systemic gaps between mental health law and community-based mental health care. Marisol Orihuela is a clinical professor of law at Yale Law School. Her teaching and practice areas include criminal defense, civil commitment, immigration, and civil rights. She directs the Mental Health Justice Clinic and co-teaches in the Worker and Immigration Rights Advocacy Clinic. Professor Orihuela's research interests lie at the intersection of criminal and immigration law and criminal and mental health law. She has written on competency and detention during criminal proceedings, social movements in the law, and lawyering in immigrants' rights, criminal defense, and on behalf of individuals with mental disabilities. And Dr. India L. Mills is a conservator, ministry leader, and advocate whose work reflects a long-standing commitment to service, restoration, and community care. Since 2007, she has been appointed by two separate Connecticut probate courts as conservator to individuals with psychiatric and physical disabilities. Dr. Mills currently serves as co-pastor of Living Water Ministries in Torrington, Connecticut, and her service includes prison ministry from 2017 to the present, work with Safe Haven of Greater Waterbury, and other outreach efforts that support vulnerable communities and families. Thank you to all three of you for joining us today. Before we start, I thought it would be good to ground this conversation with a brief overview of civil commitment by quoting directly from the article. Quote, "Civil commitment refers to the legal process by which individuals are confined by court order to locked treatment facilities for mental health conditions, substance use disorders, or sexually dangerous behavior. In theory, this should last only as long as the individual poses a danger to themselves or others. However, in practice, the process is injuriously compromised by the disconnect between the legal and mental health systems, alongside the dearth of community resources and supports. Current legal practices guiding civil commitment are stacked toward confinement. They rely on outdated paternalistic frameworks and carceral logics." Marisol and Kristin, your article includes both of your perspectives working as defense attorneys on civil commitment cases in two different states with different civil commitment laws. What did you learn by working together on this article? Marisol, I'll direct this to you first.
Thanks, Jorge, and thanks for having us. It's great to be part of this webinar. I think the main thing I learned is that I am not alone. Civil commitment defense can sometimes feel lonely or isolating, and I'll contextualize that. As a former public defender, I've asked for treatment many times at sentencing or in lieu of criminal prosecution. Treatment, medical treatment, and within it, mental health treatment is something that our society views as normatively good. Civil commitment defense, however, is the place that exposes you and complicates how mental health treatment works. One, because it is forced and mandated, and so it also implicates infringement of people's autonomy to make a basic decision about whether or not to take medication, whether or not to seek therapy or not. But two, because as the article hopefully illustrates to readers, there are many things that can go wrong even when people are trying to do the best for someone. The part that I work on talks about, when mental health treatment isn't working as designed. In a state like Connecticut, a state that, is known as a blue state, a state that provides a lot of services, we see a lot of people getting stuck in the system. And it was a true lesson to see a companion state also known for providing a lot of resources to its residents, Massachusetts, that these two states could have such similar patterns of people stuck in systems without ways of getting out.
Thank you. Kristin, your thoughts?
Yeah, thank you also for having us today. And I agree with everything Marisol just said. I think the key takeaways for me, similar to what she was saying, is just it reinforced the idea that what's happening here in Massachusetts is not unique. It highlighted that the systemic gaps in healthcare, housing, community resources exist in Connecticut and I'm sure elsewhere as well. And it also reinforced the idea that civil commitments, while they're intended to be purely healthcare related, they're intended to address a healthcare need. Often in reality, what we find, those of us that work in this system, is that it's used as a tool to respond to other social failures that are actually not related to healthcare. My hope is that our audience, while reading about our state-specific experiences, takes away a much broader structural critique that illustrates how civil commitments in general across jurisdictions operate more like a carceral continuum driven by systemic scarcity and focused more on institutional control rather than therapeutic necessity. Because I think that's something that people who are not involved with this system don't understand.
I know both of you worked together to come up with a graphic depiction of what it's like to be stuck in the cycle or maze of civil commitment, and ultimately came up with graphics showing highway exit signs and roadblocks. Can you talk about what this signifies and what you hope the reader would take away with this? Kristin, I'll start with you this time.
Yeah, so the hope is that the illustration effectively demonstrates how incredibly difficult it is for individuals who are stuck inside the civil commitment system to get their freedom back once things are in motion, once the train has essentially left the station. For me, I think the story that illustrates this most clearly was Luke's story, which was one of the individuals that I wrote about. That's not his real name, because he did what I think many of us have done, or we know many people have done, which is he went to an emergency room for a medical issue that he was experiencing. He never realized that one decision, which presumably seemed like the correct, responsible decision in the moment, could result in him being confined and nearly committed to a psychiatric hospital for up to 6 months. There's no way that he or many individuals could realize that in order to get out after he made the decision to walk through the doors of an ER, it was going to require the representation of an experienced attorney. It was going to require an independent expert that was hired by his attorney. The matter was going to have to go in a few weeks to trial before a judge, all just to get out of the hospital after he walked through the doors of an ER. And at each stage of the process, he's given false hope by the various clinicians that he's interacting with, that it's going to be one more day, one more doctor, one more evaluation, and then he'll be able to get out. When the reality is that the system actually makes it much easier to keep individuals inside than it does to get them out once they're in there. The reality is that these roadblocks, as we depicted in the graphic, they just keep coming. And so, my hope is that our illustration effectively demonstrates that.
Marisol, anything to add?
Just a few thoughts. So I think any of us who have gone on a road trip may have had the experience of thinking we're going to be able to get off the highway at the next exit. And when you see a bunch of cones that don't let you get off, okay, maybe mildly annoyed, but you think, okay, I'll be able to get off at the next exit. And what I think the intent is behind the graphic that accompanies our article is for someone who may have had that experience but has not had the experience of being in a psychiatric hospital subject to civil commitment can understand and relate to what it might feel like if every time you think there's a next exit, there's something keeping you from getting off the highway, and what may begin with a sense of disappointment because the first exit that you saw didn't work out, over time becomes incredibly confusing, disorienting, because it does not appear that there is going to be an exit. And indeed, that is, I think, one way um, that I have experienced the case that I write about with Miss Doe is that every year we have a hearing. It's required every 2 years. In practice, we've had a hearing at least once a year. And every time you think there might be an exit, something happens and there's a roadblock. The one of the stories that Kristin wrote about that really resonated for me is it's the story of Jaden and Brandon, how it's easier to get out of jail than a hospital. There in Connecticut, we know that there are people who have pled, who have didn't were found not guilty by reason of their mental health condition, who then end up spending many years beyond what they would have spent in prison and in a different locked up facility had they been able to plead. In our case, in the case that we represent, someone at the hospital, our client has not been convicted of any criminal offense, but we are approaching 10 years of detention with no clear exit off this highway. And that as a proposition, when we generally believe that we do not detain people indefinitely, is one that we hope to impress upon the readers.
Well, it's fitting that you have discussed your work on behalf of Miss Doe. As you write in the article, her psychiatric detention began in 2016, and that was after 4 years in a group home within the community. So we're talking of a pretty extended timeline here. Specifically in the article you wrote, according to Miss Doe's cousin, her closest family member and her longtime conservator, the person legally responsible for decisions about her care, The group home had just had a total staff turnover, a significant change in routine for Miss Doe. Her cousin argued she would not improve in a hospital, but rather needed to get settled back into a new routine in the community. And nearly 9 years later, Ms. Doe remained detained at the State Psychiatric Hospital in Connecticut. Dr. Mills, I believe this speaks to your experience as Ms. Doe's conservator, as the conservator that Marisol wrote about in the piece. Can you tell us more about what your role is, including what do you believe is best for your cousin, and what are the roadblocks to getting her what you believe she needs?
Sure, and thanks for having me today. So my role as the conservator is to make informed decisions on my cousin's behalf. Um, Also to ensure that her basic needs are met, as it pertains to food, shelter, clothing, healthcare, and those kinds of things. Um, my cousin thrives when she's in the community, living in the community. She's just barely existing in the hospital setting. Um, so she proved that she could live in the community setting for 4 years. And that was due to her program at the time and her clinician coming up with a behavior support plan that the staff were trained in, and that behavior support plan was implemented. And we saw the difference in my cousin was like night and day from being institutionalized and being and living free in the community. She would need today, if she were to transition back into the community, the same thing: compassionate and caring staff that would provide 24/7 supervision for her, and a tailor-made behavior support plan. And the roadblocks to that has been simply that DMIS, the Department of Mental Health and Addiction Services, the Whiting Forensic Hospital Administration, probate court, and Kim's legal team, including myself as the conservator, cannot seem to agree. And DMIS and the Whiting Forensic Administration have not agreed to come on board and state that Kim is discharge ready. So in the probate court system, a judge can discharge patients from a psychiatric facility, or a psychiatrist can deem a patient discharge ready. So we chose to go the legal route, and there has been a judge to say, I can discharge Kim. I will discharge her. My cousin, I'm sorry for naming her, because she's a person. She has a name. She never committed a crime. And she's been stuck in this position. So the roadblocks has been, even if a judge were to discharge her from the psychiatric hospital, the judge couldn't make DMIS provide the funding. There's the chokehold. And that chokehold has been in place as a yoke around our necks for close to 10 years now. And I've often said if I had the money to pay for and provide an array of supports for my cousin to live in the community, then I wouldn't have to depend on the state to do so. So funding has been a major issue, as well as home. There's nowhere for her to go. There's not enough beds available. There's not enough agencies available. And those are just some of the roadblocks.
Thank you. Marisol, what are you and your team at the Mental Health Justice Clinic advocating for to support Ms. Doe?
Thanks for that question, Jorge, and thanks, Dr. Mills, for sharing your story. The clinic is trying to employ a model of representation that Connecticut just does not see. The legal system, the system for representation of people who are civilly committed in Connecticut ignores the individual subject to civil commitment 355 days out of the year. I say that number because 10 days before a hearing on your civil commitment, you get a panel attorney appointed to your case. That attorney will represent not just you in 10 days, but every other person on the docket at that facility. So at a place like Whiting, there might be 8 cases on the docket that day. There's another hospital at the same property. Same attorney represents that docket that same day. So it might be 15 cases that day with an attorney is appointed and has 10 days to prepare for those 10 cases. And then they will not continue representing those individuals past that hearing date. That model of representation, our clinic believes, does not serve the best interests of people who are subject to particularly long-term detention. So absent representation like the kind that the clinic is offering, someone like Miss Doe for 10 years would get a different attorney. Maybe there will be a repeat after a few years because the panel of attorneys is not that big, but there's no continuous representation, continuous advocacy, all these things that the clinic is doing. So the law students who work on Miss Doe's case, they engage in regular treatment advocacy with the hospital administration system and, when appropriate, with higher level officials at the Department of Mental Health and Addiction Services. We advocate for additional funding. We advocate for community engagement. We believe that it's not that, particularly in a case where there's complex psychiatric disabilities, it's not that one day everything will work out. We know that basically things have not worked that way, and okay, magic, and you can release someone to the community. We think that there needs to be a dedicated plan for release, and we represent our client at all levels of court advocacy. So one of the things that individuals subject to civil commitment have legally available to them is the discovery process and probate court. However, when your counsel is appointed 10 days before your hearing, there simply is no time to engage in any kind of litigation. So we've engaged, because we provide continuous representation, we engage in discovery litigation. We've engaged in litigation to involve the higher level officials that ultimately are the ones who have the authority to make things shift, to create new spaces for people to enter in the community. And we've faced significant resistance. So multiple appeals by the state AGs, challenges in probate court. I wouldn't say that it's easy, but the underlying commitment that we have is consistent with the theme of this issue of the notebook, is that a representation of someone that begins and ends in 10 days when they might be detained for 10 plus years of their life is not solidarity. So we infuse our legal representation with a different kind of view that seeks a stronger commitment of care to our clients, and hope that despite the roadblocks that we might be able to have productive conversations with the relevant state officials, and ultimately be able to get our client to the community with appropriate results, with the proper supports.
Yeah, Marisol, I just want to say that if you're trying to win a popularity contest in government, you're doing it all wrong. I mean, agitating for change and positive, corrections within the system, that's
Uh,
not how you win friends in government. But
Thankfully, I'm not aiming for a popularity contest in government.
yeah. Kristin, you write that of all the injustices you witnessed in your 14 years as a public defender in Massachusetts, one of the greatest was the deeply entrenched stigma held against people perceived to have mental illness. Specifically, you write, this stigma permeates every aspect of our legal system. Can you speak more about how you saw this stigma play out in the legal system, particularly with respect to the cases that you discussed in your piece?
Yeah, I think there's a lot to say about the stigma faced by individuals who are perceived to have mental illness. But I think what I want to focus on with respect to what I wrote about in the piece is the way that this stigma shapes the way that every actor in the system interacts with our clients. So the clinicians, the judges, and even the defense attorneys on occasion. Everyone is operating with this baseline assumption that individuals with perceived mental illness are not reliable narrators of their own lives. And thus, there's this assumption that their personal preferences can be discounted when it comes to their treatment. I think a good concrete example of how to illustrate how bizarre this is when you take it out of the context of mental health is to compare it to any other medical diagnosis that an individual may have, right? That's not a mental health diagnosis. So let's take cancer, for example. Somebody could be diagnosed with a form of cancer. They could meet with their specialists, their clinicians, who could recommend a form of treatment. And they could say, this is the best treatment for you. This gives you the best chance of beating this cancer and living the longest life possible. The individual who has the cancer can accept or decline that treatment. And even if their doctors say, we think that's a bad decision, we think that's the wrong decision, they're still given the dignity and the respect to make that decision. In the mental health system, our clients are rarely afforded the same dignity. And in fact, the refusal to accept the proposed treatment is often seen as proof of the fact that they're not reliable narrators and that their own personal preferences should not be taken into consideration. So the system is not only very paternalistic, it's also self-reinforcing. It's paternalistic because it empowers individuals who are often strangers, these judges who don't know this individual, just meeting them for the first time, these clinicians who didn't know this individual before they arrived in their psychiatric facility. They're being empowered to make deeply personal decisions about someone else's bodily autonomy, about their liberty, about their future. And that in and of itself is extremely paternalistic. It's also self-reinforcing because if the individual with the lived experience tries to assert their autonomy, that is then seen as a symptom of their mental illness and further evidence and proof that they should have that very autonomy further restricted. So like I said, there's lots that I could talk about when it comes to the stigma faced by individuals with perceived mental illness. But I think in the context of this piece, that's the biggest example of that stigma.
Thank you. We're going to pivot away from discussing the piece itself and open it up to a broader discussion of current trends. But before I do that, I just want to, again, invite from the audience now at this juncture, any questions that you may have for the panelists. You can put your questions into the Q&A box on your Zoom window. and time permitting, we'll try to get through as many as possible. Otherwise, I'll just be asking all of my numerous follow-up questions because this is deeply fascinating and I want to learn more. Under this current administration, there's been a push to broaden civil commitment laws to permit involuntary psychiatric holds. Specifically, the administration's executive order on homelessness, mental health, and substance use encourages states to remove unhoused people from public spaces and broaden civil commitment laws to permit involuntary psychiatric civil commitments in more circumstances. At the same time, cuts to Medicaid funding are depleting community supports that address mental illness. Marisol, starting with you, can you speak about the dangers of expanding civil commitment laws in this way?
Oh, sure. I'm very happy to. So I want to take a step back from the executive order to kind of point out a few trends in civil commitment more generally. So one of the trends is that we're seeing civil commitment, the use of civil commitment rise, even absent the administration's executive order to kind of ramp up civil commitment and really connect it to a hot topic of addressing homelessness that is very much in the national public's mind right now. We also have seen a growth of what's called and this is mentioned in the article, out mandatory outpatient treatment that doesn't have the inpatient locked facility aspect of what we've been talking about with civil commitment, but still very much touches upon infringing on the autonomy of people to make basic decisions about their medical care. So I think what you have is, and that's been, laws authorizing mandatory outpatient treatment, which can be a way to enter civil commitment. So someone gets ordered to participate in outpatient treatment. They don't comply with the order to participate. They then basically are teeing up a case and they've already in the court system to then be subjected to potential civil commitment. So basically a new pathway in to civil commitment, while also normalizing and just the concept of we're going to force treatment upon people. So that becoming as a societal acceptance which compared to what we saw in the 1970s with deinstitutionalization, where people said, "Oh no, what's happening in institutions for people with significant disabilities is terrible. Let's put people in the community." Debates about whether that truly, really happened. But now you're seeing, I think, a resurgence of, okay, maybe if we don't know what to do with people, maybe institutionalization or forced treatment is one way to address that. So I think you already have a country a little bit primed for the executive order. Now, what can be particularly dangerous about the incentivizing at a federal level an increased use of civil commitment is that part of what happens in civil commitment is a lack of transparency. Hospitals, so you're talking about medical facilities, so there's going to be lots of protected information under HIPAA. So already a challenge for public access to information and public knowledge about what's happening. So in Connecticut, for example, I think we're still reeling and trying to figure out how to move forward from a horrible, horrible case of longstanding abuse at Whiting, which came to light because of a whistleblower in 2017. It led to restructuring within the hospital, a lot of people getting laid off, but people who were tasked with providing medical services to an individual with significant disabilities were engaging in all sorts of physical and other abuse, which people didn't know for many reasons. One of them being that people don't trust people who have significant mental disabilities because of the stigma associated with mental health conditions. So Increasing the use of civil commitment is, I think there's great dangers in the lack of transparency. Of course, I think going back to Kristin's point about stigma, you can see that at play in the executive order, a stigma that equates mental health conditions with propensity for criminal activity and depicts people who are homeless as dangerous. And tying those things, of course, helps justify to the public that these are individuals who do not deserve to be part of our community at freedom. Let's put them somewhere that is separate from where we have to see and we have to deal with as a community. Um, and of course, apart from stigma and the lack of transparency, there's the issues that we write about in the article, which is people can get stuck. We have an underfunded community housing system. We have an underfunded community mental health services system, and this proposed solution by the executive order would be incredibly expensive. So, from the point of view of how do we address societal challenges, taking the things that the executive order names as societal challenges and agreeing with them. Yes, homelessness is a societal challenge. So is the needs of people with mental disabilities, and crime is a societal challenge. But picking the most restrictive, expensive solution without trying other solutions, I think is incredibly dangerous. I don't know how the legality of the executive order will play out. I'm aware of only one piece of litigation that challenged it, that was dismissed for lack of standing. So I think in Connecticut, I haven't really seen it absolutely enforced yet, but I suspect that there may be litigation, and there's some careful wording in the executive order that I would imagine is in there to try to protect it from legal challenges, but it certainly doesn't follow the traditional standard on limitation of the government's authority to civilly detain somebody based on for purposes of treatment, which requires danger to self or others, grave disability. So it adds a homelessness category, which in practicality we're seeing because people get stuck because they have nowhere to go. But as a legal matter, I think there's some real questions there about whether it would stand up in court.
Thank you. Kristin, can you comment on the impact of Medicaid cuts to important support services in light of, of the broader context of these administrative pushes toward pushing more people into this system?
Yes, definitely. So I think that what we are seeing is a deeply concerning converging of these policies that are both expanding the civil commitments on the front end, right, which is what Marisol was just talking about, and then also weakening the back end supports, which actually make discharge and recovery, less possible if we have less options out there. Medicaid is the single largest funder of community-based mental health services in this country. So when we cut that funding, the practical effect is that the very services that are helping individuals remain in their communities, remain with their families, maintain their stability are going to start to disappear. There's just not going to be the funding available to keep them open. And that's all. We already don't have enough, right? That's already one of the drivers that's creating this carceral civil commitment system, is not having enough of these other outpatient supports, housing, and things like that. So then when we start cutting funding that's providing outpatient supports, you're making this problem exponentially worse. I could tie it back to our illustration in the article, right? Which is that the effect is that we're not only reducing access to services, we are effectively closing the exits, right? So these exit ramps that were hard to actually achieve are being shut off even more by cutting off the funding sources that would allow for appropriate discharge plans to be put in place for these individuals. And we are going to start seeing this. And as Marisol said, even before this executive order, we were already seeing this play out in real time in courtrooms, in hospitals, where individuals are going to be subjected to even longer commitments and have even fewer discharge options available to them. And what we're doing is we're taking a system that was already focused on containment, and we're making it even more focused on containment and even less focused on treatments, specifically any type of treatment that would be self-directed or still honor the individual's personal choice.
Thank you. That actually pivots quite nicely to the next subject that I want to address, which is about solutions, right? We've talked a lot about what doesn't work or hasn't worked, or may yet still not work, depending on your view. And so let's talk a little bit about what we would like to see more of. Dr. Mills, I'd like to direct this to you first. As a family member and a conservator of someone who has been civilly committed, what is one thing that you would change about the system that you think would help improve outcomes for people like your cousin? Oh, sorry, you're still muted. Sorry.
That's a hard question, because there's so much or so many things that's wrong with the system. It's hard to just point out one thing. My personal experience of being related to a person that has been subject to so much unfairness and mistreatment in this particular facility, I find that the system is broken, and how do we repair something that's so broken on so many different levels? And so in my mind, I'm thinking the only way to fix it is to tear it down and then rebuild it, you know, with the focus being on the individuals with disabilities, because I believe that the focus has been taken off of them. My cousin hasn't received any therapeutic treatment outside of medication for such a long time. That's something we've been advocating for years. And it's one of her psychiatrists testified under oath that she could benefit from this, my cousin, this type of therapy. And she still hasn't been given occupational therapy. You know, the staff turnover is another big thing that we're dealing with, especially for my cousin, who it takes so long for her to build up trust in individuals and then a very short time to lose that trust. So I'm thinking, you know, I've had so many, I've had countless encounters with unprofessional professionals. And I've said to myself plenty of times that my cousin has better sense than some of these so-called professionals. The way that they treat family members that is in the position of a conservator appointed by the courts. I can't think of a word that describes it. Very, the treatment is very belittling. I've been told until I go to school and become a medical doctor, then I can't give my opinion of what the doctors should and shouldn't do. Although I've been given the authority to consent to psychiatric medication or not consent to that. So one of the changes I would say I would love to see is that the probate court would give more oversight, like that they would oversee um, things that are being done uh, against the patients in this facility and hold them accountable for their wrongdoing. And I believe Marisol and the folks at the Yale Law School Clinic are doing a great job with bringing to certain individuals to see that they're not doing right in this particular case and instance. So I want to thank them for everything that they're doing.
Thank you. Marisol, continuing with this question of solutions, we've talked a lot about supports and the need for community-based supports, and probably one of the most critical in that is deals with housing. When there's quality supportive housing available, presumably there's less need for civil commitment. Can you talk a little bit about what types of supportive housing states should be investing in? What does that solution look like?
Any and all is my answer to that question. I find it so interesting that housing, take us out of this webinar. The need for more housing is almost universally accepted and recognized in this country now. Um, and I was reading an article about, I don't know, I was reading a New York Times article about what this country needs, and people are like, I think the headline was "Build, Baby, Build" or something like that. Build more housing. Like this is how we got here. We need more housing in order to change, move from where we are right now. There are, I want when someone when someone with a significant mental disability, for them to thrive in the community, I think the question then becomes, what kind of supports do they need? Now, all of us need support in all sorts of different ways. Regardless of the whether you have a disability or not, we all need supports. And when you have a disability, you may need supports. You may need medication assistance. You may need prompting to take that medication. You may need help getting to appointments. Someone with a mobility disability, may need help with transportation to get from place A to place B. That concept is not, the concept of support and care for each other in a community is not a complex one. What ends up happening when we're talking about people with significant disabilities, for the many reasons that we've discussed, is that they get excluded from the conversation of who gets the thing that we're trying to build. So we can have lots of conversations about building housing. And suddenly, for some reason, we're having a separate conversation about housing for people with mental disabilities when it could all be part of the same conversation. And we could talk about what the different types of housing that we want to have for all members of our community. Our client needs housing with significant supports to thrive. That I I have not heard hospital staff um, in the past few years say that they don't believe that she could be in the community with appropriate supports. We hear a lot about she is not the term clinically stable right now. And that is what they want her to achieve in order to be in this community. But we could, if you increase the supports, the level of stability that you need stability in order to get to the community changes. That concept is a relative concept to the support that you're willing to provide somebody. And so when we talk about housing, there's different level, like, you know, sometimes people need a little bit of support and they don't have a home and they need a bed and, heat when it's cold and things like that. And sometimes people need staff there 24/7 in order to help them thrive. And in Connecticut, we have different levels of housing available that is funded by the Department of Mental Health and Addiction Services. There's a website. It's the bed availability website where you can check every day to see what the community placements are that are funded by the department, and what the availability is. And it is constantly a column of zeros. And that's the reality that we have in Connecticut. Um, and so that's why I say any and all, because the more housing that you provide, yes, for our client, we want additional housing with high levels of support for people with complex psychiatric and behavioral needs. But any and all is helpful to the large numbers of people with different needs that are locked up in our facilities today.
Yeah, I just want to take a moderator's privilege here and comment on the fact that it's pretty remarkable that the term clinically stable is used as a diagnostic term, or at least an indicator of someone's kind of current state as an individual, right? As a patient, as someone who's receiving this type of treatment. But really, it's much more broadly an indicator of what the state isn't or can't otherwise provide outside, right? Like it's reduced to that, right? And it makes it seem as if, oh, this person is in this situation because they can't or have not reached clinical stability, when that's not really the issue. The issue that we're talking about is that this is the only place where the state has demonstrated a willingness to provide the resources necessary for someone to achieve
Y-
clinical stability.
Yeah, I want to comment one more thing. Which is maybe a little bit in legal weeds, but there's a Supreme Court case called Olmstead that basically says when someone is ready to, it can be in the community, you know, it violates the American with Disabilities Act to keep them institutionalized. What that creates is an incentive for hospital systems to not say that someone is ready for discharge. Because if you say that someone's ready for discharge, question then becomes, are you violating the ADA? And so what ends the relationship between what's happening in the community and what's happening and how someone what is incentivizing hospital systems to name in medical terms is present and somewhat a result of the way that legal cases are determined, because in order to avoid liability. So in some ways it helps me understand what may be happening, even though for purposes of how we might want a medical system to operate, you don't want it operating with that in mind.
I see that we're winding down in terms of time, but I want to just ask one question to Dr. Mills, which is relates to your status as conservator for your cousin and the responsibility that comes with that, specifically, being put in a position to advocate one way or another, or help direct the therapies or the treatments that are offered to your cousin. How do you go? That seems like a very challenging task, to be put in the position to try to help decide or determine what is in the best interests of your cousin and to try to use that responsibility to achieve the best outcome for her. How do you go about that process of understanding what those best interests are, or what you choose to advocate for on her behalf?
So my cousin and I grew up more like sisters rather than cousins, and we've known each other for 55 years. And so I know the difference between my cousin and her illness. And uh, she trusts me. We have a very trusting relationship. And there are times where, many times, that she has confided in me. Um, I know her diagnoses and things of that nature. Um, when things are reported to me, I pretty much know um, her, and at times why she responds the way that she does. And so that's what helps me to advocate for her the way that I do and ask for certain therapeutic things to be put in place. And so basically, she has PTSD. One of the things is um, paranoia and things of that nature. But she was also seen for many years as being oppositional and defiant. And so I fought some years ago to have a psychological evaluation done. And through that evaluation, it came out that she was not being oppositional and defiant, but that she required more processing time. And so in my cousin's case, she not only has a psychiatric disability, but she has an intellectual cognitive disability. And that's something that they cannot provide medication for. And so I advocate for, like special accommodations and things of that nature as it relates to her cognitive disability. And Marisol can attest that even that's been a fight to get her things that she needs as an individual. I find that the treatment plans that individuals are supposed to have are supposed to be individualized to that particular person, but oftentimes they are um, given to multiple people, like the same plan. And so I find that my cousin in particular, who is a rape trauma victim, that's overlooked oftentimes in her treatment plan. So why would you have a rape trauma victim, just for example, on a unit with 27 men? You know, things of that nature. And so I advocate around her needs. And a lot of times I get pushback, and Marisol can attest to that as well. It's been difficult, but I don't give up because she deserves this level of advocacy. And I won't stop until she's released from that facility. And I believe she will be. It's unfortunate that threats have to be made. It's unfortunate that lawsuits have to be filed. It's unfortunate that they, Demas, as well as the administration of Whiting, will not just simply do the right thing because it's the right thing to do.
Thank you. We're at time, but before we leave, I want to thank all of our panelists today for participating, and thank you to all of our viewers for attending. The full recording of this webinar will be up on our website shortly. Our next and final webinar is Using Narrative to Move Policy, which will be held on May 19th at 1 p.m. Eastern. There, David Gaspar, CEO of the Bail Project, and Jenny Espinoza, CEO of Back to the Start, will offer strategies for collecting and leveraging powerful stories that shift public understanding and influence policy change, particularly within justice reform movements. You can register for that webinar in the events section of our website. And don't forget to download or order our notebook on that website, justicehappenshere.yale.edu. Thank you so much, everyone, for joining us.
Thank you.